I do have skills that make me a nightmare for people like you.
Everybody, how are ya? Part 25. This is in regards to the $60 parking ticket saga. Part 25, it's basically the correspondence, the backwards and forwards, changing of goalposts, changing of positions, breaching of fiduciary duty, statutory obligations, breaching of my rights. This is the bullshit that I've had to put up with since the day after I won the court case, to try and acquire a complete copy of the case file or court file, or at least just getting the judgment, because I have nothing in writing to say the judicial decision found in my favour. I have nothing in writing showing the transcript. I might have evidence that I won that isn't in writing, but I'm not going to mention that. People might get upset. But at the end of the day, the following is the correspondence, the backwards and forwards between myself and Divya Ojha, which is the Deputy Registrar at Waitakere District Court in regards to judge-alone trials or criminal jurisdiction. And basically I've lost count of numerous bullshit stories in these emails back to me. You'll notice through these emails there is no name of any judge supplied. There is no direction supplied. Now, if they are saying that I have to fill out some sort of application to exercise a pre-affirmed right because they don't want me to miss out something, you would think it would be common sense to let someone view the case file so they know what's in there to know what to ask for. But of course, logic and reason, common sense, doesn't work well with the legal system because they don't use logic, reason. It's all assumption and presumption, absent facts. So, without further ado, the first email was from myself to Waitakere District Court, and it reads as follows. Good afternoon, and this was on the 2nd of April. Please supply under the District Court Access to Court Documents Rules 2017, Section 9.3, the transcript in relation to CRI 2018-090-005689 on the 1st of April for our records. We further require a complete copy of the case bundle in relation to this matter to complete our records under the District Court Access to Court Documents Rules, Section 9.3. We do appreciate this may take a week or two given the resources at the transcription service and to compile. We would like to thank Davina, Philippa and all the staff at Waitakere District Court, including the court security officers, for their respectfulness, courteousness and professionalism during the course of these proceedings, and thank you all for your tolerance and support throughout the course of this matter and proceedings. We also request that the Registry please convey our sincerest appreciations to Her Honour Judge Lisa Tremawan for her time and considerations. Please inform us as to when these requirements and requests can be completed at your convenience. Okay, following that I got a response, well actually I didn't. See, what the Registry tends to do is they like to pass the buck. So the Registry, being Rutaia, or R-U-T-A-I-A, no last name supplied, Rutaia emailed Divya saying, Kia ora Divya, can you please assist with the below request? Okay, difference between a request and a requirement. A request is asking. A request is made without authority. To require something, you have authority and power to require something of another person. When I require something, it's because I have a right, and they have to oblige me by supplying what I require. When I'm requesting something, they can say no, whatever. But when it's a requirement, I'm expecting my servants to obey. And all she did was forward the email I sent to her to Divya. Now, 3 days later, I get a response from Divya saying, "Good morning, Mr. Keane. Thank you for your email. Your request for transcript has been actioned. However, as you mentioned, it will take some type to be delivered to all parties." I'm taking she's meaning time, not type. "I understand that you have everything presented in court on the 1st of the 4th, 2019, including exhibits and submissions. Can you please specify what do you mean by case bundle?" This is a deputy register not understanding what I mean by case bundle. It's in legislation, it's referred to as case bundle. Case bundle, complete court file, case file, it's all the same fucking thing. Right there, Divya is telling me what she understands. Well, she's misunderstood. Because how does she know what I've got? She hasn't spoken to me before, she hasn't asked me what I have, so how the fuck does she know what I've got? She doesn't. April the 5th, I respond back to Divya with the following. "Good morning, Divya. No problem. Allow me to specify with an example. In 2018, we defended successfully an allegation between Police v Keane. At the conclusion of the matter, we requested, attended, inspected and received a complete copy of the entire case file / bundle. Although we had the majority of what we received, we also required internal emails associated with the case and district court copies of the charging documents, which on the reverse side had notes made by presiding judicial officers in relation to the matter. As I've said before, on the back of any charging documents where judges like to write their little notes. Now, I'm entitled to a copy of that. It's in the case file. If they didn't want people to know what they're writing about each other, they should make separate little notes and keep them secret. However, if they're going to write something on a charging document, which is a document in the case file, I'm entitled to it. Irrespective of what the, "oh, that's a waste of brain space," servant said to me by Waitakere District Court on the 17th. He understood that there must be a direction from it. He understands nothing. All of you muppets behind the counters at district courts are not legally trained. You don't get to play lawyer, you get to follow procedures, rules and legislation. That's what governs what you're supposed to do. What you believe, understand, think. It's got no relevance whatsoever. I wasn't asking any of you fucking dropkick public servants behind the counter, I wasn't asking any of you for a legal opinion. I knew what my rights were, and I was expecting you to abide by the law and comply. You expect blind obedience, compliance, trust and confidence from all of the general public, and yet you fuckers don't do it yourselves. But again, you get a little power crazy. You've got one tenuous, minute speck of power, and you go overboard thinking you can use it. Wrong. As far as this matter is concerned, as we did not receive back the 4 photographs submitted to the court by the defendant on the 1st of April 2019, 2 photos dated the 24th of October, 1 photo dated the 11th of January, and 1 photo dated the 17th of January 2019, we would like these originals returned once Waitakere District Court has a copy of them for their records. They're my original photos. And to avoid Waitakere District Court supplying another tree load of paper, and to avoid doubling up and further expenses to Waitakere District Court, we would like to arrange a time to return to Waitakere District Court and inspect the complete case file / bundle and copy any documents within which we have no record of, including but not exclusively the charging documents with Selwyn's and Lisa's notes on the reverse. We comprehend that it might be a waste of time and resources to supply doubles of that which we already have. However, judicial notes being part of the file bundle is mainly what we require to complete our records, along with the transcript from the 1st of April, of course. We would also like to know how much money was spent in conducting this case, which, in hindsight, AT should never have filed in the first instance. as we will be returning to AT in the near future to have them refund and void the other 11 allegations still open against other trusting road users, which we are aware of through Official Information Act requests, which AT unlawfully issued infringements against. We hope this clarifies things better for you and will await a time and date from you so we can inspect the file bundle and get copies of what we do not have for our records, in accordance with the District Court's Access to Court Documents Rules 2017 Section 9.3. If we do not receive a time and date to attend for this purpose, we will, at our convenience, return for such regardless. Again, we thank you and the other Waitakere District Court staff for your continued assistance. It is very much appreciated. So I'm being nice, alright? I'm being respectful. I'm not being abusive. I'm not giving them any cause to be complete fucking arseholes in return. But that must be just a prerequisite for being a public servant at a district court. Now, I don't want to paint every registrar with the same brush. There are few and far between court staff that will actually follow the rules and do what they're supposed to do. But when you get power-hungry muppets like Divya that choose to overreach their power, go past their scope of authority, then that's where you're going to get problems. Okay, so on the 11th of April, Divya responded with, "Good morning, Mr. Keane." Now it's Mr. Keane. "Thank you for your email. Please find attached notice of application. Kindly complete and return by email. This then will be placed before Judge who? For her a female judge, for her consideration. However, Judge is currently on leave for 4 weeks and your request will be attended to following her return." Okay, so now she's informing that Judge Lisa Tremowan, now she's not saying Lisa Tremowan, but she's saying she, and she's saying that she's away for 4 weeks, and I know through past experiences that the presiding judicial officer needs to read through the transcript to make sure that it's accurate and okay before they sign it and then allow it to be released to the parties. So I'm going to presume, judging by what Divya is saying, that she's meaning Lisa Tremowan, but I don't know because she's never identified. And that was from Divya. They sent me 2-page notice of application form. Which basically is under Rule 2.12 of the Criminal Procedure Rules 2012, so it's using a completely different legislative provision to allow me to access these files. I've already stated under what law, what provision, Rule 9.3, that I'm asking for. The fact that they are now changing the goalposts and telling me to fill out these dinky forms, and this form has nothing to do with it says, do I request an oral hearing? Estimated length of time for the hearing. I don't want a hearing. I want what is owed to me, my documents. I'm not asking the court for anything else. This shit is to do with current proceedings that are still active. Mine's closed. In Section 9.2, in case Divya didn't read that bit because she seemed to think, oh, it's closed. So what, that means I don't access it anymore? Section 9.2 states any party can exercise those rights at any time, which means in 4 years' time I could go down there and ask for these documents. They still have to supply them because I am a party, and because I am a party, free of fucking charge. Normal people, normal members of the public that want to access a court file may have to fill out an access to court documents request. Certainly not an application. I'm not applying for anything. I'm not begging for fuck all. I'm trying to exercise rights that they are currently obstructing. On the 11th of April, I respond back to Divya with, "Good afternoon. Please explain what this notice of application is in relation to. What are we applying for? As we understand it, we have requested and require the court transcript for the hearing dated 1st of April 2019. Also, we require a time and date to inspect and, if required, copy any and all documents we do not have in relation to that case file under District Court's access, and I repeat the same section. If a suitable time to attend to inspect and copy this case file / bundle cannot be specified prior to our attendance, we will come at a time suitable to us and exercise this right at our discretion, as Waitakere District Court keeps these records on site, which you do. Now, the last email was on the 11th of April. Heard nothing for 9 days, so I sent a chase-up email on the 20th of April. Good morning, could you please answer my question? What is this application form you supplied for? Regards, me. On the 29th, another 9 days later, I get from Divya, morning Mr. Kane. It's just morning now, it's not good morning. As a self-representative, you are entitled to have a copy of the charging document. No, Divya. As a self-representative, or as a successful defendant, I have a right to copy every document unless a judge has put a restriction on it, which you have to prove in writing. I don't care whether he told you or she told you in oral direction. That means shit, because I wasn't there to hear it. And I'm not taking your lying ass's word for it. So produce the direction, produce the minute that this oral direction was written and noted on to me. But you can't, because you are lying. As a self-representative, you are entitled to have a copy of the charging document, in brackets, only front sheet. So already they're trying to hide the judicial notes. But since you requested for a write-up, no I didn't. I've never used the phrase write-up, because I don't know what the fuck a write-up is. What I've asked for is to inspect, search and copy the court file that I'm a party to. I'm not asking for write-ups, I'm not begging for fuck all. I'm exercising my rights, and you fuckers are obstructing it. Request a write-up, we need application to place application in chambers before we can release any further write-ups. In relation to photography presented in court by defence, I can leave copies at counter for you to collect. But you didn't. You held them all, asked me which ones I wanted. You didn't give me fuck all, did you? You let me briefly look at the charging document, and when I started reading out the notes on the back, you tried to snatch it back out of my hands. Unbelievable. If you wish to view the court file, please email me. I can arrange for that. If I wish to view the court... Are you blind? 3 fucking weeks prior, this was the 29th of April, on the 2nd of April, perhaps English is not your first language, but on the 2nd of April, I informed you really clearly that I wanted to search and inspect and copy the case file. Now you're asking me 26, 27 days later if I wish to view the court file. Fuck off. I wish to search, inspect and copy it. That's what the legislation says. And you do not have power to stop that. You, as a registrar, only have to supervise. You don't control it. Yeah, I might seem a little emotional. That's because after dealing with bureaucratic bullshit for years, studying law, muppets behind counters that overstep their rules and boundaries, I have no respect for. On the 1st of May, I respond. Good morning. Please explain what a write-up is. As no application was needed for the successful defended case at Auckland District Court for them to supply myself a complete case file, and no direction or order from any judicial officer restricting access to these public records, Waitakere District Court are required under Section 9.3 of the District Court Access to Court Documents Rules 2017 to supply the documents requested. Should you wish to infringe on this right, this will be dealt with in an appropriate manner. Perhaps Selwyn wrote his notes and doesn't want me to see them. Or is there something else Waitakere District Court wishes to covet? How far is the transcript from the 1st of April? Please advise. Because, don't forget, she said it had been actioned. P.S. We will seek legal advice prior to completing any application which we believe is not required, according to previous cases. Now at that time, I contacted Waitemata Community Law Centre. I left a message, they responded back to me, and even though I stated the exact rules, they said, oh, you best fill out the application.
Hi, am I speaking with Mark?
Yes.
Hi, I'm calling from the Waitemata Community Law Centre.
Oh, hi.
Just in regard to the parking infringement.
Yeah, or accessing the transcript and Facebook. Yeah.
Yeah, so the best course of action would definitely be to fill in the form and then wait for them to come back to you. We just have to follow that process.
Am I right in thinking, though, that I don't have to fill out a notice of application, that I have the right to access this document without an application? Because every other time I've asked for a transcript from any court in the last 2 years, they just supply it without any application needing to be filled.
Yeah.
So,
If they've told you that you have to fill in a form, then you would have to do that.
okay, even if it goes against what I'm allowed anyway. I mean, I don't care if I have to fill it out. It just seems like it's another gate that I have to go through to get what I'm already allowed.
Yeah, I understand.
Because Section 93 of the access to district court access to court documents rules says that I have, unless the judge puts a restriction on it, which he has.
Yeah.
I don't get why I would.
So pretty much, yeah, okay.
Am I right in interpreting that, or not?
Yeah, I mean, I think it's at their discretion.
So why are the rules even there then? If they have the discretion to state. I mean, don't they have protocols and procedures to follow?
Yeah, they definitely do. But I mean...
Yeah. You can understand my frustration because
yeah.
in the last...
Was there a reason that you needed access to the transcript?
Yeah, because I put a submission in to actually record the hearing and they refused. They refused my right to actually keep a record of the proceedings separate from the Ministry of Justice. And they said to me that I'd be allowed the transcript. And for the last month and a half since the hearing, Waitakere District Court have led me to believe that the transcript's at the transcription service and then I'd get it. It's only because I actually asked for the complete, I wanted to speak on a copy, the complete case bundle, that now they've done this, need to fill out a notice of application rubbish.
Yeah.
And it's because I know on the back of the charging document the judges write their notes, and I want to see what the judges' notes are.
Right.
So, yeah, but, I mean, I'll fill out the form, and I just think it's another
Yeah.
Perhaps it's because they're getting published on YouTube. I don't know. They tend to not like transparency. But my point is that AT illegally unlawfully issued the ticket because of misleading road marking, and I found out through an official information act request that they had done 11 other people in the same spot. So I want the transcript so I can go to Auckland Transport and say, here's the case law. It was, you've issued it unlawfully, now go and void the other 11 tickets that you shouldn't have issued.
Yeah.
I can't do that unless I've got the transcript in my hand to stick it under their nose.
Yeah, okay. Well, I mean, definitely in that case, if you want to take it further, I'd go and fill out the form, and then you've followed every thing that they've put in front of you, and then you can present like a full case to the Auckland Council once you get everything issued.
Sure.
Yeah.
Right, well, thank you very much for your assistance and your help with things.
No worries. All the best.
All right, thank you. Enjoy your day.
Thanks. You too. Bye.
Bye.
That was their answer. Why did they do that? Because lawyers' first duty is always to the court, not to me. If the court or registrar is saying I have to fill out an application, they're not going to go against that. Although, unless they produce a minute with that direction in it, I ain't filling out jack. Unless they prove and show me a minute from a judge restricting access to my public case file, release it. It's a parking ticket. It has nothing to do with any sensitive nature, other than the fact that I show Auckland Transport up for being unlawful. I show the warden up, perjuring himself on the stand, telling me no, they weren't misleading, or saying they weren't misleading when the plaintiff or when the prosecutor had them on the stand. Oh no, nothing's misleading. But then I get him on the stand and he says, yes, I can see how they're misleading. He tells me that he checked the road markings. It says on his report, road markings checked. Visual check, yes. Road markings okay, yes. What a liar. He never walked anywhere near the car. How do I know? Because I was there the entire fucking time, either sitting in the car or right outside it. I knew where he took the photo from because I stuck my head around from the little concave because it was raining, and I saw him standing in that concave on private property, Waitakere District Court property, taking photos. And yet he says, no, I stood on the sidewalk. Another lie. You couldn't have taken those photos, Steve Lammy-Satali. You couldn't have taken those photos unless you were standing in that concave of the district court, because you captured the cabbage trees. You could only have that angle from being behind them. Ridiculous. Anyway, so on the 1st of May, I get from Divya, morning Mr. Keane, write-ups are referred to notifications from jury. Really? I thought they were called minutes. A minute is a notification from a judge. Don't know what you use write-ups for. Perhaps you could show me where the word write-up is legally defined, Divya. Or are you just going to try and confuse people by using jargon that I've never used and yet say I asked for? I didn't ask for fuck all, other than to exercise my rights and have you respect them. As mentioned earlier, judge is away and transcript might be released mid-May. Oh, now it's might be. On the 1st of May, I respond, hi, thank you for explaining that. We will get back to you in relation to inspecting and copying the case file bundle. We appreciate you reiterating that Judge Tremowan is away. However, we did not know the date Her Honour would be back. We thought it prudent to ask. It is now a month since the hearing. Mid-May is fine. Many thanks. Okay. So, 7th of May. I received, good afternoon, Mr. Keane. Judge directed to file notice of application regarding any court document, including transcript. Unnamed judge is directed, according to something the judge said to her, although nothing's in writing. And so basically right there, to me, that's a lie. If someone's directed something, you could say Judge Tremowan. Identify the judge. But instead you're just saying all of this bullshit without anything to back it. And you're just trying to say, because they told you so in an oral direction. Now, the normal person would just believe, oh, it was an oral direction, it's just something she heard. That's still hearsay as far as I'm concerned, unless she can put something like that in writing. Whenever a judge directs something to be done, they put it in a minute. It's not a difficult thing to comprehend. On the 7th of May, I responded to her with, good afternoon, please inform us, is there a direction from a judge restricting access to these public records currently, given we are party to this matter? And then I sent her a copy of the General Rights of Parties to Proceedings, which is Section 9 of the Access to District Court Access to Court Documents Rules 2017. Followed by, please supply the direction from the judge you are referring to that has directed a restriction on this public record. To our knowledge, there is no current restriction on this matter, and the transcript and case bundle should be supplied upon request from us, which we have done. Is Waitakere District Court refusing to supply the transcript given we have a right to such records? What grounds have the judge placed a restriction on, if indeed there is any currently? Why are Waitakere District Court changing their position, as you have stated previously that the transcript would be supplied with any application, as has happened every time we have requested in the past? Why is Waitakere District Court not complying with District Court Access to Court Documents Rules 2017? We shall seek legal advice as to the failure of Waitakere District Court to supply these documents on request. Followed by response on the 10th of May. Morning, Mr. Keane. Thank you for your email. Judge has asked, so it's an ask now, it's not a direction, that an application be put in writing with specifics of what you are requesting so that no information you want is left out. How thoughtful. I'm touched. Please find attached an application for access to the court documents which will be processed upon receipt. After receiving the application, it will be placed before a judge for further direction. See how the goalposts are changing? Now, she already sent me that notice of application a month beforehand. Now, she's sending me this application to access court documents. This is something a member of the public fills out if they want to access a case file, a public record. Okay? It's really that simple. They have to go through all different steps explaining why they want it, give reasons, and it's 4 pages long with a fifth office use only page at the end of it. You know, even if you fill out one of these forms, this would then be placed on the case file, and then if I wanted a copy of the case file, I should get a copy of this too. It seems simple, doesn't it? But yeah, so now we've got 2 different applications. We've got notice of application and application to access court documents. This one, the provisions on this one are all based under... Where is it here? Oh, they refer you to the Media Information Guide, which tells you if it's a rape case or involving children. There's restrictions on those sorts of things, or violence offences. Let me just see. So it says here, criminal. We are asking for access to the documents under the criminal procedure rules. Well, no, I'm asking under the district court rules. But under the criminal procedure rules, clearly I can access them that way too. Yeah, not much else in there. A judge or registrar at the relevant court will review your application. You will be contacted as soon as possible with their decision. So again, this refers to criminal procedure rules, just like the other one. So therefore, none of them have anything to do with my rights that are affirmed in the district court rules. Moving on, May 10th. It says here, I've sent it to Divya again. Good morning. So which form is it you request we complete? The first notice of application form or this form you have supplied today? You have failed thus far to supply any current direction from a judge, whomever it may be, as you have failed thus far to identify him or her, placing any restriction on this public record, which we, as a party to the proceedings, according to the legislation we have supplied, have the right to inspect and copy, without any application needed to be completed. We will complete this application under duress and protest, as you have failed to produce any direction to date, nor supplied any provision in law where this form must be completed before exercising our right as a party to access district court records. As we have not inspected the complete case file / bundle, we do not know what is in it to require a copy of. Which judge is concerned we may have information missed out. As we have not inspected the complete case file or bundle, Should you have any question as to ADC supplying the complete case bundle in a previous matter without any form being completed, please see the below link. And I supply a link to my public record of me going into Auckland District Court, waiting for around 40-50 minutes, and then having Rita yell at me across the level 1 public area there and go, "Mr. Keane," and then I get marched in, followed by security, because they're all insecure, and then they have 2 duplicate copies of wads of paper about that thick, and they must have spent ages copying all of that. But then I gave them prior notice that I was coming in, and they respected my rights. They actually gave me a complete copy. They also supplied me other information that had nothing to do with me whatsoever, to do with a completely different case. When I pointed out, they asked me to please destroy it. Of course, I destroyed that copy that I had because it was in a piece of paper. It was easy enough to screw up. But then, of course, haven't destroyed the email they sent me, because that email contains everything else too. So, tough. This is why we request a time to attend and inspect, as is our right, the case file. As you are aware, we have requested the ability to exercise our right to keep an impartial digital audio record of this open public hearing, which was refused by Judge Glubb, stating that the court would keep a record and the transcript would be available. However, now Waitakere District Court and an unnamed judge claim that a form, which in the last 6 hearings we have attended in the last 2 years have never been required previously. We will attend at a convenient time to us next week or so to inspect the file as to correctly fill out your form, as we would not wish to miss out anything. Respect our rights as prescribed and act within the law. Warm regards, me. They responded back to me on May the 10th. Morning, Mr. Keane. Please file application that was attached today. Okay, so they're telling me the latest 5-page form they want me to fill out, not just the 2-page one they supplied a month earlier. Fantastic. They can want all they like. Good morning again. Can you please identify the judge and supply the current direction in effect restricting access to CRI 2018-090005689? We reiterate, as it appears to have been overlooked by yourself, we will attend next week to inspect the complete case file / bundle as to correctly complete the application form you have supplied today, as we wish to waylay the judge's concern that we may miss out some information required. See you next week. And that was on the 10th. I get a response back on the 10th. Hello, Mr. Keane. You are more than welcome to view the court file. However, just to emphasise, we won't be providing you any photocopies from court file. I am in court next week, but will be available to assist you Wednesday and Friday. Thank you and have a good day. Followed by, on the 10th of May, my response. Hello again, Divya. Thank you again. We will not need Waitakere District Court to copy anything, as you has emphasised. We will have our own ability to copy anything we have a right to. Would love for you to explain why Waitakere District Court and Auckland District Court operate differently. Are you not both district courts? We are aware that any servant working for the Ministry of Justice is immune from civil prosecution for any error or omission. But does that mean each district court just does as it wishes? Make its own rules and policies, irrespective of what is prescribed in legislation? Look forward to meeting you in person and having the direction and identity of the judge that is concerned that we may miss out something provided. Why have you ignored our questions in relation to this so far? Does the person obstructing our rights affirmed not wish to be identified or supply any direction? Never mind if you don't answer today. We can always ask again when we meet. Enjoy your day. Thanks again. Me. On the 10th of May, I also reiterated and sent this to Divya. Something else to note, Divya, as ADC happened to have information pertaining to other cases mixed into previous matter and breached the Privacy Act by supplying them to us and to inspect, it may pay for you to make sure no other individual's information is supplied by Waitakere District Court to us to inspect. Given the district courts we have dealt with track record, best you make sure. Thanks again, me. Okay, and then I think it's in part 22 I've already published, where I actually show what happened when I went in there on the 17th to inspecting copy. Divya stated that there was an oral direction from a judge. I said I'd like a copy of that in writing. She said that will just take longer. I pointed out the law to her. She tried to play lawyer. She is not legally trained, so she cannot interpret the words correctly. I've already had those words interpreted for me, so I know exactly in the legal interpretation what it means, and it means I have a right as a party at any time to search, inspect and copy any court document in regards to a simple Category 1 criminal offence, parking on broken yellow lines. Now, it's interesting in the case that I never objected to there ever being broken yellow lines there. I never objected to the car being parked there. I never stated I was the driver, because that's irrelevant. It doesn't matter who the driver is, because they will just go after the registered owner. It's only if the registered owner wasn't the driver and feels like dobbing in their mate, then they'll sign a statutory declaration, which the courts and police and or Auckland Transport can then use as a statutory declaration made against another individual to then prosecute that other individual. It's not rocket science, okay? But because the judge found that any road user, when taking into account the P90 sign that was right there, any road user coming along the road would first and foremost see the white hockey sticks. They would not necessarily see the broken yellow lines at the curbing first, so therefore they would pull in, and then if they were just to get out of the driver's side and walk across the road to say Harvey Norman's or something, then they would never even look at the passenger side of the vehicle, and therefore they would be misled in combination with the sign and the markings that it was a valid car park and that they had 90 minutes to park there. Auckland Transport, by their own actions, because I made the complaint, fixed it. So I could show before and after photos in court that they had actually repaired the fault. Therefore, the fault existed. The Official Information Act requests I filed showed that they'd also ticketed other people. They supplied the dates of these tickets. They never supplied the infringement numbers, and I may still go back and ask under an Official Information Act for the infringement numbers, because that is not private information, and all I need to know about with those infringement numbers is whether or not they're void or still being pursued, or whether or not the two people that paid have been refunded. Otherwise, Auckland Transport is committing fraud under Section 240 of the Crimes Act, where they're basically gaining money through deceit. Okay? They're still keeping money that they know was from an unlawful action on their part, which I proved in court. I warned all of these people that this would happen. They still chose to do it. When you look at the different failures of Auckland Transport, the failures consist of, first of all, the warden not doing his job properly. Okay? I still suspect the warden, because I witnessed the warden go into Waitakere District Court and talk to court security before coming out and issuing my car the ticket. Okay? And he did it from the little concave right by courtroom 1's entry that's always locked, with the vandalised and crappy looking crown crest and the emblem that's sitting up on the wall that's all been defaced, and no pride whatsoever in that building. And he stood in there because it was raining and because he didn't want to be seen by me, because I was standing right along the cream coloured building's wall, but I was right up against the wall, and because he was shooting on an angle, I was in that blind spot and he couldn't see me. Shortly after, I stuck my head round because I saw him walk across the road and I hadn't seen him for a few minutes. I popped my head out, looked past and saw him standing there with his phone. Okay? So I know, I witnessed him standing in that concave when he had his phone out, taking photos. Okay, he never placed the ticket on the window. You might argue because it was raining. The other point is because I was there. He didn't want to have a confrontation. He wanted to be a sneaky little fucker and then reprint it on the 16th, 4 days after the allegation, and then post it to me. So I didn't get it until the 24th. Alright, took 8 days for them to print it, for me to get it. If anyone else in Auckland sends me something, I get it within 2 to 3. 3 because it's rural delivery. Add an extra day for that service. So the warden failed. He failed by issuing an unlawful ticket, by not correctly noting down that the road markings were improper, and by not ringing up and getting the fault fixed. Not only he faulted, but 3 other wardens also did the same thing in that time period from September to January. The adjudication team failed because they clearly didn't look at the photographs I supplied. It clearly shows the white hockey sticks. They all say, yes, we can clearly see there's broken yellows, but they must be colourblind because they don't see the white hockeys that are also there as well. They just ignore that fact and say, yeah, all your photo shows is broken yellows. It also shows white hockey sticks. It shows conflicting road markings in one spot, therefore misleading. It does not convey a clear and consistent message. They were not properly maintained, and it's all in their own manual, page 64, 65. And page 131 states, where there is conflicting road markings, no offence exists, and no notice should be issued. So they breached their own rules. Page 157 of their parking compliance training manual says that Auckland Transport has to satisfy the burden beyond a reasonable doubt, which they failed to do. So the adjudication team failed and then just carried on with we'll threaten you with debt collection. Good job. I just requested again for a court hearing. So that's deemed as being a not guilty plea. Just by sending in a request for a court hearing, they automatically will deem that as a not guilty plea. So therefore, you're not just entitled to initial disclosure, you're entitled to full disclosure from the get-go. This is something police don't seem to note, because they failed to even supply initial disclosure until the defendant hearing, the second hearing. So yeah, there's so much to learn, and you keep learning every time you go through a process. You learn new tricks, you learn new things, and I've learned ample this time. So moving on, adjudication team failed. Then the supervisors and area manager that apparently inspected the operational procedures that were done clearly didn't inspect the road markings, because they said that the tickets were issued lawfully and they were happy with it, and just chug on down to court. Then Vanessa Oliver, who's supposed to be impartial and independent, stuck straight from AT's side straight away, did not clearly look at the evidence, and I sent photos to everyone. The evidence was there. It's all over YouTube. It's irrefutable. Every comment says he shouldn't be issued a ticket. There was the comment where they said yellows overrule whites. Okay, that's fine. It sounds like that came from Steve, because that's the exact same thing he said on the stand too. But the average road user doesn't know that yellows overrule whites. We know that broken yellows or solid yellows, you shouldn't cross them, and that they are a mandatory effect. But most public don't know that whites are only advisory. You know, they're only a may not type situation. They're not a do not or you must comply type shit, which is what yellows. I mean, what's the point of even having whites there if they're not just to give you some sort of guidance or direction? So yeah, I could go on for ages. I'm still going to keep chasing this. I've gone to the local MP, Chris Pink, Emily McGowan is looking into it. She's going to go and talk to Waitakere District Court in regards to the harassment on the sidewalk when I was recording, and again with their breaching of my rights. They're breaching their judicial duties, statutory obligations, breaching district court rules, all of these things that they have openly done on record. Chris Heard responded to a complaint that I sent through on the 24th, shortly after I found out about my friend being kicked out of Waitakere Court for doing absolutely nothing wrong other than exercising her rights and remaining silent and not talking to police, not answering questions. And she got bullied, harassed, threatened with force and kicked out and trespassed for the day. So nothing formal. And I got a response from Chris saying that I can't sue civil servants. Chris, you need to look at Curry versus Clayton 2014, where under the exact same section that you specified that the Crown can't be prosecuted for torts, this person successfully appealed and did win. It also mentions in paragraph 90 and 91 that parties have a right to access the court documents. So, yeah, I often wonder if Chris has ever actually seen the inside of a courtroom, if he's just one of these paper pushers that doesn't actually know fuck all, or operates through some incorrect legal interpretation. But it's clearly stated in case law. You can go to judicial decisions online and you can easily look up Attorney General versus, and there are hundreds of cases where private citizens, private individuals have filed civil suits against the Attorney General because they must be named as the primary defendant, and then the individuals that were working in their capacities as well. It's the only redress we have. You can complain to the JCC about judges. You can complain, which does nothing. 2,838 complaints in the last couple of years, 0 have been upheld. What's the fucking point of them? Same goes for IPCA, or the IPCA, where you've got the Independent Police Conduct Authority run by ex-police officers. Okay? There's nothing independent about that. It's really that simple. And there are many people that have filed civil suits against police in one too. Anyway, see yous all. Don't want to leave this too long. It's probably about an hour long now, so I'll leave it at that. See you guys. Much love. We'll keep you updated. As soon as I know something, you'll know something. Bye.
Rainbows in the dark. Cock it, let it go. Load it, cock it, let it go. Load it, cock it, let it go. Load it, cock it, let it go.